everyone. How are you doing? Hello. Hope you're good. Hope you're fine. You're welcome to Lawyers Info Hub. It's a great pleasure to create content on this channel. Hope you're good. How is life? How is practice? How is studies if you're a student? This platform was created out of passion to help in growing the legal education in Nigeria. We are supporting the growth of the legal profession in the little way we can, and we hope that the content we drop on this platform will help you in one way or the other in your career development, in your career goal, and in all you do to becoming a good and a better lawyer. So today we're looking at mediation in tenancy matters. We have done series of topics concerning tenancy, types of tenancy, types of lease, quit notice, notice of owner's intention to apply to recover possession, all that pertains to letting out a house to a tenant, terms and condition, and all of that. You know, this is one of the commonest brief a lawyer can get with respect to managing of property. We've also done a video on issue of managing a property, how you can manage a property effectively. In managing the property, a lot of things happen, and you can encounter tenants who do not pay or who don't pay at certain when due. You can also encounter bad tenants who just want to frustrate you as the manager of a property or as a owner of a property. So today we're looking at how mediation works in tenancy matters. And is it the right option? Is it the right thing to do? Are there the advantage? What are the advantages? How can we tailor it in, to the benefit of both parties? Mostly in magistrate courts, when tenancy matters are come up before the magistrates, they tend to give room for out of court settlement. Now, sometimes I wonder why some tenants will have to wait until it gets to that point of going to court for them to now start saying, I want to settle and all of that. That also brings me to say that when you're letting out a property, because what we're sharing here is also not only peculiar to lawyers, but to other people who have things, to do in this respect, and also for knowledge sharing purposes. Now, it is expected due diligence. Sometimes people are after the financial benefit to them rather than to ensure that this person you're letting the house or property to is a good tenant. As much as you can know everything, but it's also important to do due diligence. And it's also very important that once the rent is due, or even before a rent is due, you notify. It's not just about collecting rent. It's a relationship between the tenant and the landlord, or tenant and the agent who's managing the property, or whoever is the maybe property manager. It's a relationship, so you should be on tab with your tenants to know when is the rent expiring. When they notify them maybe 2 months before time, 1 month before time, 2 weeks before time, your rent is expiring. And if there is need for them to ask for time, you discuss, okay, what time should I give? When are you paying and all that? Then once it's obvious that the tenant doesn't want to pay, you need to do the needful by issuing the statutory notices, which are the beginning point in commencing recovery of premises process. Now, as much as many people love to go to mediation centers, depending on your jurisdiction, there are mediation centers set up by government. There's also a mediation center set up by organizations. You see, some organizations have set up maybe in localities like rural areas where people utilize. There are also, if you are in a state that has state-owned mediation centers, a lot of people utilize it. A lot of government has set up mediation centers to sort out these minor issues and beyond tenancy, other matters. So in these tenant and mediation centers, what they usually do is that when you come and lay your complaint, uh, you know, uh, they send an invitation to the tenant. if it is the tenant that's having issue with the landlord and the tenant makes the complaint, who is the complainant, a notice or kind of an invitation is sent to the person. Now, because of logistics, sometimes they give it to you, who is the complainant, to go and serve, or you can also mobilize them to serve. So when they serve, falls, it has its own pro and cons. That is why in matters that can be resolved, it is encouraged that parties should seek ways to resolve it. Even in complex matters, parties can still sit down and resolve their issues. Now, so in tenancy matters, it is not an exception. Parties can sit down to resolve their issues. Now, when you go to these mediation centers, some of them, they have qualified mediators. Some of them have lawyers who work with. Sometimes these mediation centers are creation of the local government, or they are situated in the local government. Some of them are creation of the Ministry of Justice. Some of them are creation of the courts, but located in different places, depending on your jurisdiction and what happens in your jurisdiction. So this, some of them are certified mediators, some of them are lawyers, some of them are not just lawyers, but because of what they are used to doing this mediation, encouraging them who mediating, they're now used to the process, and they are just officers who act as mediators. You also note that to even be a mediator, there are also professional courses can do to be a certified mediator. That aside, now when the parties come on the scheduled date, they will hear both parties and say, okay, what are the ways we can resolve it? It's a party discussion. Parties are involved in the discussion. They find a way to resolve it. The mediator, speaks to both parties, sometimes differently, together, to see how do we resolve it. This person wants to settle. What compromise can you make to see that this settlement pulls through? It sometimes involves the shifting, compromise, each person making a little compromise here and there for the resolution to be made. So if parties can't settle, then they enter terms of settlement. But sometimes this settlement doesn't end in one meeting. There's sometimes rescheduled 3 or 4 times for parties to resolve all their issues, and it is entered as what like a kind of an agreement between parties. And sometimes in tenancy matters like this, you see, maybe they will say the tenant have to have 3 months, or depending on 1 month time to pack out. This is how you pay his arrears. Are there arrears you're waiving off? Also, if the matter has been instituted in a court of law, in magistrate court, high court, whatever it is, and a party who is dealing with the tenant in this instance raises the issue of, I want to settle. Counsel for the claimant, the defendant comes to court to say, my lord, we think we can settle the issue. Some lawyers believe that why stress yourself over tenancy matters? Why do we want to waste money, waste time, waste resources on tenancy matters we can resolve? Many people are open to this. Many magistrates, encourage. Even some of them begin to ask questions, begin to act as mediators. As much as they are magistrates, the judges, they stand in as mediators to say, okay, how many months do you want? What exactly is the problem? You're not paying rent. Okay, when are you leaving? They sometimes have seen instances where in court, a magistrate is asking someone, how many months do you want? And the person says, okay, give me 6 months. She will say, okay, or he said, this 6 months is too much. Oga landlord, or Mr. Landlord, or Mr. Man, or claimant, what can you do for him? You can say, okay, I will concede 2 months to him, or I will concede 3 months to him. These are ways to resolve. And most time, I tell you, 80% of tenancy matters have been resolved through mediation, either in the court or outside the court through the mediation centers. So resolving tenancy matters using mediation is a long-age practice, and it has come to stay. I know we are improving on it. We are encouraging lawyers to get certifications in mediation, arbitration, any other means of out-of-court settlement. Because even in our rules encourages amicable resolution of a matter. Even the in the rules, the option protocol guidelines and all of that, is expected that before a party brings a matter to court, there have been steps taken towards the resolution of the matter. So it's also very important to note that in mediation in resolving tenancy matters, you see, sometimes many people are not like, no, you must pay everything you're owing and all of that, are not willing to shift grounds, especially on the part of the owner of the house who feels, You can't go and live like that. It's a business, you're ruining me, and all of that. Also, considering the nature of our judiciary, the courts are overpopulated in terms of they are overwhelmed with a lot of cases. I know adjournments sometimes take 1 month, 6 weeks, and you see that sometimes you see that you take 1 year, 2 years trying to resolve these issues, and by the time you're done resolving the issues and you get the judgment in your favor, another process is the enforcement of the judgment, which is another process. And by the time you even enforce the judgment, take over and maybe take the properties in there, go to the court and all of that. By the time they auction those properties, all these things is not an instant thing. It's not instant. It takes time. It takes time. And you see that sometimes many people at the end of the day now regress. Why didn't we at least settle when we had to? Because at the end of the day, you may not be able to even get half of the money you're looking for. Now, maybe we also end to some of them may have money in their account, some may not have. As much as out of court settlement is very much encouraged, when you are in a matter either for the landlord or the tenant, whoever you are for, it's also expected that a counsel, as a minister in the temple of justice, that you embrace, open your hands to the issue of settlement. Try it. If it fails, fine. You can't force it on people. You can't force it on people. As much as some tenants are really, 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 really so annoying, as you can say, some are like intentional in their actions. Some other owners of the house are not also too fair. So it's depends. But it's expected, and it is a good option if mediation is called in to see how parties can resolve the issue. And when parties resolve the issue, terms are entered, filed, and terms are agreed and filed, and it's not entered by the court as consent judgment. Wherein, if maybe the party is supposed to leave at a certain point, and the expiration of that point, that month or the date, the party is still there, you can go and enforce your judgment. So mediation is one of those effective ways that help, even in other cases that is not even tenancy matters. You see that mediation has been used, arbitration has been used to, resolve the matter. And it's always a happy moment when a magistrate or a judge hears that a matter that they are handling has been resolved. I was once involved in a case where the judge was thanking us profusely for allowing peace to reign. You could see the joy for a judge who saw that parties reconcile. It was so, I was like, wow. She was so full of joy to see that a parties, they were thanking the parties profusely, like, thank you for allowing peace to reign. It showed me that it's like one of my docket, but at the same time, it also shows that parties, irrespective of their differences, can really sit down to discuss their matter. So either way, if you are counsel both for either the party or for the owner of the property, don't close your eyes or close your mind or encourage your client against embracing out of court settlement or mediation. As much as it may not be favorable, or you can't shove it down their throat, but give peace a chance. If it's not going to work, it's not going to work. But don't just shove it aside and don't even give it a try. You expect to give it a try. If it doesn't work, you are satisfied that you tried. I know in tenancy matters, sometimes when you get these briefs and it comes to you, you are the one, money. You see some lawyers, not all lawyers, some lawyers will start giving some very clear advice to their clients, all aimed at making the client feel like they have worked to earn a fee. Sometimes you need to tell the tenants the truth. What is the position of law in this regard? They are owing, the right processes were served, it was duly acknowledged. You now keep letting the tenants know that you have this right, you have this right. As ministers in the temple of justice, we must always learn to speak the truth to our clients, irrespective of whatever is at stake. Let the client understand what they are into. Let the client understand the real position and, okay, what are the ways we can work around it? What are the ways to resolve this issue? But when you start giving clients hope that we can be in court for 3 years, nothing is going to happen, it's kind of um, encourages such a person. the person might leave that place and go back to another property to replicate that bad attitude or behavior or non-compliance to terms agreed in the tenancy agreement. So I believe that mediation has helped so well in tenancy matters as well as in other cases. And I encourage you to also in your practice, you can utilize it as much as you can't force your client to accept it, but you can show the client reasons why parties can resolve, save time, and see what can happen. Give it a try, give it your options. If it doesn't work, fine, but don't shove it aside. So I believe that you know going forward, if you have not started utilizing it, utilize it. Yes, utilize it. When the other party writes to you, calls you to say, okay, these are the things. Okay, share the propositions with them. See if what your client can accept. If it's not what your client can accept, okay, this is what our counter offer is. If both parties can resolve it, then you can proceed with trial. I don't know, but you're satisfied in your mind that you didn't close up that opportunity. You didn't close your mind to the fact that there was a need for parties to sit down and you blocked it. So, friends, it's been an amazing time. I believe in mediation. I believe in parties settling the differences. I'm an advocate of out of court settlement where possible, where possible. And it's also very important to know that um, lawyers can improve themselves in getting certification in these areas, in arbitration, in mediation. Can be a certified chartered mediator. Yeah, can be a chartered conciliator, a chartered arbitrator. Different things you can do. These are skills you can acquire as you grow in the profession. And most of these organizations like that handle all these certifications, these are also another area where jobs can be created. You see, they have cases and they invite lawyers who are already chartered, who are already trained in that field to work. So if you feel it's only the law thing you need to do, think twice, get other certification to boost your lawyering skills, to be up to date, to be top notch, so that you can be able to function in other dimensions. If you're yet to subscribe to this channel, please do hit the subscribe button, share this video, and like, save. You see, one thing I love about a channel is that when you drop questions, we answer them. So if you have questions, comments, you're encouraged to drop them. I believe in the best. Believe in being the best. I believe in working hard, because I know that hard work does not kill. What kills is laziness. So I believe in excellence. So I believe in being the best wherever you are. Be the best. And you know what? The sky can be your stepping stone. Yes, the sky can be your stepping stone. So in whatever you're doing, tell yourself, I'm the best. I can be the best where you are not yet the best. Train yourself, be willing to unlearn certain things you're not supposed to learn, be willing to take corrections, be humble, work hard. I know what? The world will be under your feet. Do take care of yourself. Share this video. Someone needs to hear this. Share this video, like it. You can also click on the notification bell, touch the notification bell, so that whenever we drop a new video, you will be notified. We are here for you. I will keep doing what we are doing, because we know that we are helping someone out there. It may not be you, but someone else needs to hear what we are saying. Thank you, and do stay blessed.